So for my case briefing, I decided to do Parent versus SAD number 75. And this case took place on March 22nd and 23rd, 2016. So the facts about the student. The student lived with his parents and his younger sister. He was eligible for special education services under autism and intellectual disabilities. He also has a language disorder, and this means that their communication was limited. Even though he was understanding certain languages, he was having a hard time understanding it fully, which made it so he was not that of age appropriate. The district had always said that the student was always happy and that the district loved working with him. Some background information on the case. So Kelly Ann, who was part of the lawsuit, was the student's teacher when he was at this district. She had the role of a special education teacher, an autism consultant for staff, as well as working with the students due to an IEP standard. The relationship oftentimes grew tense between parents and staff due to the mother showing up unannounced. Kelly Ann was asked to be removed from the case manager once the parents knew that she decided to do a grievance, which meant that she did not want to have the role of a special education teacher within the district due to the parents thinking and using a comparison to that of Nazis and the way that they were training the students or the Nazis in the concentration camps. Some more background information. So since the communication was low for the student, the IEP implemented ways to communicate between staff and parents, meaning that it was daily logs. The ed tech would oftentimes communicate daily at the end of the day with the mother, and the teacher would also communicate daily during the morning. The district was oftentimes very receptive to all of the changes from the parents. If the parents asked for something to be changed, oftentimes they would change it immediately. So after a while and after the parents realizing that this teacher was attempting to leave due to a grievance, they decided to have a meeting. And in the meeting, the staff oftentimes accused the mother of spying on field trips. There was an instance where the mother was actually at a grocery field trip. Granted, she was trying to state that she was just behind the school bus and she got stuck behind the school bus, which would be the reason why she showed up to the field trip. The same day, the student was very upset when he was being picked up. There's no explanation why for this, and this is unusual behavior for the students, which caused concern for the parents. The parents decided to result in an action, meaning that they wanted all written and verbal communication about the student. They were requiring the student to wear a recording device so that the parents could understand what the student was dealing with, understanding his daily goals and what he was going through throughout the day, and that they felt if they had the recording device that the parents would be a more accurate way to help during the IEP process. The school also asked that there was an IEP meeting to be done before they brought the student in with a recording device, just so that everybody could be on board and that they could come up with a better solution if need be. So why the recording device? The parents wanted the recording device to not only understand the whole day, but to be able to take part in a meaningful way during IEPs. They felt that the school was not providing accurate information because there was bruising on the arm of the kid one day, and parents felt as if this child was not being safe, and that the sister also was coming home and saying certain information to the parents about what the school was doing. So the recording device resulted in a very tense and hostile classroom environment because parents were asking that the other students were being taken out of the classroom, which meant that their privacy wasn't necessarily being affected for the other students and the teachers and even the ed techs. So some of the preliminary matters and or legal questions. The first one, did the district violate state or federal special education laws? Did the district fail to comply with timely annual review? Did this district violate the IDA by failing to provide documents related to autism consultant services? Did the district's actions in not permitting the students to wear a recording device while at school deprive the right of the parents to participate in the IDEA decision-making process? Did the districts change the students or staff in the students' classroom during the winter of 2014 constitute a change of the student's placement? Did the district violate state and or federal special education laws by failing to provide the student with autism consulting services under the student's IEP? Does the IDA require the district to provide the father upon demand with the names of educators who participated in a union grievance over 2 years ago? And finally, if the hearing officer finds a violation of applicable special education law, what remedies, if any, are appropriate? So for part of the holding, the U.S. Supreme Court had held in an administrative hearing challenging an IEP. The burden of proof lies within the party seeking relief. And this is, if you look down here, it shows the case that this came from. So this meant that not only did the parents have to prove that the evidence supports their positions, but the school had to as well. And if the school and or parent could prove that evidence is supporting, the hearing officer can make a decision. So after the preliminary matters and legal questions, it was proven that the district was right on track and they did not violate any of the state or federal special education laws, meaning that the district understood that the student needed a post-secondary transition plan, which they did provide. They also were able to comply with the annual review. They did not violate in not providing the autism consultant services to the student because they were still giving it to them. The autism consultant services were not meant for that person to be his number one-on-one. The autism services, consultant services, were to watch the student, understand the student, and help people understand how to work with them. As far as the actions in not permitting the student to wear a recording device, this meant that the student could not wear it because not only did it affect him, it affected the other students and the teachers, the ed techs, because of privacy. And that meant that the parents did not have a right to let the student do this because it didn't deprive them from the IDEA decision-making process or the FAPE education, because at the end of the day, they were still getting all of the recording logs. They were also getting all information that they needed in order to be a viable part in the decision making for their child. As far as the students' changes during the classroom, it didn't violate it because unfortunately with the student wearing the recording device, they were having to keep up with allowing other students their privacy. And like I said before, the district did provide the student with the autism consulting services, which was under the IEP. And finally, the IDEA does not require the district to provide the father with the names of educators because of the fact that that's not applicable to the student. And finally, the thinking questions. Why did the parent feel as if the student was not receiving the best, free, and appropriate education? Were there more concerns to feel as if the school was not a safe place for the student?